Good afternoon, council. Can you hear me?
Yes.
Yes, we can.
Yes. Perfect.
Yes.
Yes, we can.
Great. Thank you so much. Are we anticipating any other attorneys logging in for this hearing? It looks like I have at least one person from each party, but just want to make sure.
Nobody else from the plaintiff.
Great.
Fine.
No, this is. Yes. It's a reminder telling us to get on this. Oh, we're on it.
rise. This honorable court is now in session. Please be seated.
Good afternoon, Your Honor. May I proceed?
Go right ahead.
Good afternoon, everyone. The matter before the court is civil action number 2483 CV 00692. Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC et al. Your Honor, parties are all present via Zoom.
Okay, seems like we have at least one attorney for all parties.
Correct, Your Honor.
Are we waiting on anyone?
No, we're not, Your Honor.
Okay, so let's talk first, Attorney Diller, about the status of the plaintiff's efforts to access discovery that was provided by the defendant Reed.
As of 3:00 p.m., Your Honor, the newest load file was still loading and mapping to our system. And that's as of 3 p.m. today. It looks like it's working, but it is still loading. And that was the status for the last couple of days.
So that would be consistent with the court's efforts to try and access the information, because our IT department has experienced some issues during the download process. And in fact, in several instances, the download failed after running for hours, requiring a restart. I mean, we have about 12 of the 15 files in the first batch, but you can't review any of the contents until all 15 files have been downloaded and combined. So I guess who's going to speak on behalf of the plaintiffs? I mean, on behalf of Ms. Reed.
I am, Your Honor, Attorney Rosenberg.
Okay, so what do you suggest everyone's supposed to do?
So just to be clear, what Mr. Diller is describing is different than what it sounds like Your Honor just described. We've been working with the plaintiffs and their e-discovery folks a lot since our last status conference last week. And they are at the point where they have access to all of the documents. They have certain load files which provide certain types of metadata. The last additional piece of metadata they asked for, we provided, and that load file is just processing within the e-discovery software that they use. So they're not having trouble downloading it or accessing any of the documents. What we know is, according to Mr. Diller's office, as well as the e-discovery consultant that they're using, is that this latest load file appears, I won't say they've said this definitively yet, because they have not, but they've said that it appears that it provides what they need. So Mr. Diller's referring to the loading, which is fine, but it's not the same as not being able to download or access them. I've had lengthy conversations with all three other parties to confirm that everyone is able to access all of the documents. We're working through normal, issues when 1 million pages of documents have been requested and produced, but I don't believe that any of the other parties are having the kind of issue that you just described, Your Honor. And obviously, if you would like, we're happy to connect with the court's IT folks who are looking at these to address anything that you would like us to.
Well, no, that's all right. I appreciate the offer, but I mean, at this point, Attorney Rosenberg, it's not like I want to read all the documents. I mean, the issue is making sure everyone has access to them. Okay.
I figured, but I thought I would ask, Your Honor.
So, I should have made a record of everyone that's here. So, Attorney Diller's here on behalf of the plaintiffs. Who else is here on behalf of the plaintiffs?
I am, Your Honor, B.B. Fell.
Okay, anyone else? All right, and I see Attorney Halstag on behalf of CNC. I see Attorney Hassett on behalf of Waterfall. I
Yes,
see else on behalf of Ms. Reed?
Your Honor, Damon Seligson on behalf of Ms. Reed.
Your Honor, Thomas
Okay.
Tang on behalf of Ms. Reed.
They always try and tag team us all, right? With multiple appearances here.
And Your Honor, Sarah Shipley also for Ms. Reed.
Oh, okay. There's a new participant. Welcome, Attorney Shipley.
Thank you, Your Honor.
Do any of the other parties want to comment on their efforts to access, again, just the discovery that's been produced by Ms. Reed electronically? Okay, no takers. I think we have to try and
Judge, I was
the
just going
issue.
to add, excuse me for interrupting, David Hassett. I was just going to add, Judge, we have been on the phone as well with Attorney Rosenberg and his e-discovery vendor. And it appears that the remedy for our problem is going to be a different discovery. Instead of a PDF form, it's going to be in a TIFF form, which is going to be reproduced to us in the expected time frame for that to convert it to the new platform, which should be accessible to us as middle of next week. And that is as of this morning, Your Honor.
Thank you. So, unfortunately, I anticipate this might be a problem going forward. And so I want to try and make sure we get ahead of it. So I'm going to order that all the parties participate in a conference regarding electronically stored information. And the purpose of that conference is for the parties to develop a plan relative to the discovery of electronically stored information. And you can take a look at Rule 26F2C for the issues to be discussed at that conference. Consistent with the rule, I'm going to order that the parties honor before the end of business on March 3rd, file with the court a plan and a statement concerning any issues upon which the parties can't agree. And the parties can include as well whether there are any issues remaining relative to accessing the discovery that Ms. Reed has produced so far. And we're going to have a Rule 16 a Rule 16 conference about electronically stored information on March 5th at 3 p.m. And I understand you may all think it's kind of overkill, but we've been dealing with this issue for too long, and I want to avoid the issue coming up in the future relative to other electronically stored information. So now anyone else want to offer anything on those issues? Okay, so now let's talk about the depositions. The parties provided me, the parties identified, if you can believe it, 61 depositions they wish to take collectively. And unfortunately, only 20 of those depositions were duplicates. So that's 41 depositions that have to take place. And it appears that Attorney Reed's attorneys are the only ones that have noticed any depositions, unless I misread the filings of the parties. So have any of the other parties noticed any of the depositions? Okay.
No, Your Honor.
So
Not for formal dates, Your Honor. We had previously noticed some, but those were stayed and now aren't on our list.
all right, but I've only been on this case since November, and it's concerning to me that since then, there hasn't been one deposition that's been taken. And as I said at one of the earlier court hearings, you're all doing nothing, and I'm not saying that in a negative way, but doing nothing about depositions, and you're doing it at your own risk. And I've said that in some of the other pleadings. See, we got to get some of these things moving along. And I don't want to have to keep having court hearings, but it appears I'm going to have a few more than I wanted to. So, does anyone want to talk about any deposition issues?
No, Your Honor, for Ms. Reed, as you said, we've noticed every deposition that's on the notice that we filed with the court. They're scheduled roughly to begin in March. There's a lot of them, so I think we've got the outside is on July 1st. But you know, there's not a ton of dates in between those dates. We've tried to put everything on the calendar in a way that works, understanding that there may be some that need to move around a bit. But just to give you a sense of, from a scheduling standpoint, where the parties are with just our depositions on the schedule.
The problem that I see occurring is that if we don't get other depositions on the schedule, then it's just going to extend discovery too long. And you'll note to date, I haven't extended the discovery deadline. And it remains that discovery deadline of sometime in August. So I think the parties need to get together. Maybe you can use the benefit of all being on a Zoom for the conference about electronically stored information to try and map out a plan for discovery. So I'm going to schedule a conference for March 31st at 3 o'clock, again by Zoom, as all these hearings have been and will be, for a report on the status of depositions and discovery, as well as any other discovery issues that may arise between now and then. Any issues with that date from anyone? Okay. Are there any other issues that the plaintiff would like to discuss?
Your Honor, as it relates to accessing the documents, which is what started this dialogue today, one of the issues that we have as it relates to the depositions is we want to have the benefit of being able to navigate those documents. I can share with you that we were advised, based on what was sent to the court, that what was turned over in discovery was each of the 66 notices of discovery from the Commonwealth. When we issued our requests for documents, there were 37 requests with subparts. Request number 1 asked for the 66 notices of discovery. Requests number 2 through 37, maybe there's an overlap, maybe there's not. Part of the problem we're running into is being able to figure out what's compliant with those requests and what's not. It formed a basis for us to have previously served a motion to compel. Specifically, we were requesting the load files, which we have since gotten, and which is what is continuing to be loaded so that they become more usable for us. But number 2 was we requested that we be provided some index about what was provided in response to the 37 requests that we have, so that we can at least understand if there are documents that we are expecting that are not forthcoming. We can move to compel them. If there are documents that there's no privilege logs been provided to date, so I'm not aware of anything that's being claimed as privilege. But we're just trying to navigate that discovery so that we can take these depositions and access the document. So would the court be inclined to suggest that there be some index of those documents as provided? I know that there is an index for each of the 66 notices of deposition, but as it relates to what was requested, it will take us time to match those up to figure out what's related once we have a usable access to them.
Your Honor, if I could respond to that.
Well, let me ask a question first. Attorney Diller, have you spoken with Attorney Rosenberg on the issue?
Yes.
Okay. All right. Go ahead, Attorney Rosenberg.
So first of all, there's no motion to compel before you, Your Honor. And Attorney Diller is asking you to, quote, provide guidance. It's not guidance. What he's asking you to do is change what Rule 26 says about what, and Rule 34 says about what we have to do. Well, here's exactly what happened. Plaintiffs served document. Well,
Hang on, Attorney Rosenberg. Excuse me for cutting you off, but there's no motion. I don't want to have to hear these types of issues without the parties having spoken. All right? So
I agree.
What you're supposed to do under the rules. And if you need to come to court, that's what we're here for.
Understood.
But
Understood, Your Honor.
please communicate with each other as best you can. I'll throw that in at the end, okay?
Understood, Your Honor. Thank you. I don't need to respond if you're inclined to wait for a motion.
Any other issues, Attorney Diller, that the plaintiff would like to raise?
As it relates to the noticing of depositions, I appreciate that we provided a list today to the court, which totals 41 separate depositions between all the parties. And I appreciate that as of either yesterday or today, the Reed team actually served notices. But to the extent that I'd ask for the court's indulgence as we move through to navigate this process on trying to accommodate the scheduling of them amongst the four parties. We intend to cooperate and deploy as many resources as possible in order to get through all those depositions. But I just wanted to say that those dates that have been noticed as of today aren't dates that necessarily work with our calendars. And so we'll be working through that process before we meet next time.
I'm sure there are dates that aren't going to work for many of the attorneys. So I also anticipate experienced attorneys should be able to work out those issues and be reasonable. Anything else, Attorney Diller?
No, thanks, Your Honor.
Okay. Attorney Holstag on behalf of CNC. Anything?
I have nothing, Your Honor.
Okay. Attorney Hassett?
Judge, nothing further at this time.
Thanks. Attorney Rosenberg?
No, Your Honor.
Okay. We'll see you all on March 5th. If anything else comes up, just get a hold of the clerk.
Thank you, Your Honor.
Thank you, Judge.
I'll see some of you on Tuesday as well.
Right.
Yes, Your Honor.
All
Thank
right.
you.
Thanks very much. Have a good day.
Thank you.
Okay, so just for the record, this matter is continued to February 17th, 2026 at 3 p.m. for that motion hearing. It's further continued to March 5th, 2026 at 3 p.m. for the Rule 16 conference and March 31st at 3 p.m. for the status conference. Thank you all.
Thank you.
Thank you.
Thank you.
Thank you.